my name is Adam Olsen, and welcome to Indigenous Voice. It's an honor to be able to spend an hour with you to host this edition of Indigenous Voice. With me today is Doug White and Roshan Danesh, and we're going to have a conversation through this episode about Aboriginal rights, title, consent, how we got to where we're at, and hopefully how we get to a better future and a much better discussion. Doug, I just wonder if you could take a moment to introduce yourself to our audience.
Sure, Adam. Thanks very much for the invitation to come here to be with you to talk about these important issues. My name is Doug White. I'm from the Snuneymuxw First Nation. My co-Salish name is Kwulasultun. I'm a counselor at Snuneymuxw, and I'm also the director of the Centre for Pre-Confederation Treaties and Reconciliation at Vancouver Island University, a member of the BC Aboriginal Justice Council, and a number of other positions and work that I've been involved in for a number of years across the province on advocating for Aboriginal peoples in different ways with respect to the Crown. So happy to be here to talk about this important issue of consent and treaty rights and Aboriginal rights and title and what it all means for us at this particular moment in time in British Columbia.
Awesome, thank you. Roshan, maybe a little introduction to our audience. Who are you, and how did you get to be on the stage with us?
Great, thanks Adam, and really happy to be here with both yourself and Doug. Like Doug, and we work a lot together, I also work representing First Nations across both the province and across the country. A lot of my work now is for the Union of BC Indian Chiefs on title and rights issues and consent issues. And not being Indigenous myself, I sort of come to this work in a different pathway than Doug. I was actually living, doing a lot of international peace building work overseas in post-conflict areas in Africa for the United Nations and others. And at the same time was finishing my doctorate in constitutional law. And as I just reflected more and learned more, I thought a lot of that work is work I should be doing here at home. That, you know, there's sort of a responsibility to sort of bring both, you know, what I had learned academically and what I was doing on the ground with hard conflict and apply some of that here to these critical issues. So it's been a real honor to be working with the nations for about 15 years now, and I've really learned a lot and look forward to the conversation.
Well, thank you for the work that you have done and the work that you will do. I wonder if we could start with you, Doug. We are on pre-Confederation treaty territory here in Victoria, and I'm just wondering if you could maybe give us a scan of a quick scan of Canadian history as to and the relationship between the Crown and First Nations, Indigenous people in our country and in our province, as to how we got to where we're at. I think the language around the duty to consult and engagement is language that's familiar to British Columbians, but maybe you can shed a little bit more light on that.
Yeah, sure. It's a very interesting story, and I should say too that I'm also a lawyer. Roshan's a lawyer. We worked together at Mandel Pinder, is where we first got to meet each other, and we've been working together intensively over the past decade. But some of the stories I'm going to share are at the core of the whole development of Canadian law on Aboriginal issues. As you said, we're in Victoria today, down in the territory of the Indigenous peoples in this part of the world that entered into a treaty relationship with the Crown in the early 1850s. That was all premised on a very simple, basic idea at the core of English law about settlement in other parts of the world and how that settlement has to unfold with respect to the Indigenous peoples that are already there. It was very clear to James Douglas and the others that were involved in the Hudson's Bay Company, that, of the proprietary colony of Vancouver Island that was established by the Crown in the years after 1846, that prior to settlement they needed to establish a proper relationship with Indigenous peoples. And based on that idea, what became known as the Douglas Treaties, 14 of them on Vancouver Island, 12 down in Victoria, 2 up in up around Fort Rupert, Port Hardy, and 1 in Nanaimo, so 11 down in Victoria, were entered into, partially for settlement in Victoria and then for resource extraction up in Fort Rupert and Nanaimo. And so that was in an era that ended with the Snuneymuxw Treaty in 1854, December 23rd, 1854. That idea that we have to respect Aboriginal title, that Aboriginal title matters, that the relationship between the Crown and Indigenous peoples is critical and it must be established on a respectful foundation of recognition, That idea ended with the Nanaimo Treaty in December 23rd, 1854, and we entered into, at that point, a very long period of Crown denial of those basic things. The denial that Aboriginal title matters, that we need to enter into treaties prior to settlement or resource extraction, all of these ideas that then became deeply rooted in BC history started to take shape very early on in the colonial era. And so where I'm from in the Nanaimo and Nanaimo, the first major Aboriginal rights case of the modern era of Canadian Aboriginal law began in the summer of 1963. And in that summer, two men were hunting for deer in the mountains of Nanaimo, and they were charged for hunting deer out of season under the Provincial Game Act. And they had to go to court and stand up, and their answer to the magistrate was that when the magistrate asked them, what do you have to say about the fact that you've been charged for hunting deer out of season? They stood up and they said, our answer to this charge is that there is a treaty of peace between the Nanaimo peoples and the Crown that recognizes our right to hunt in accordance with our own laws and traditions. And this is now 110 years after the treaty was entered into. So 110 years of denial. We got to a place where, in BC history, where the very reality of the Douglas Treaties was denied itself. And so the issue in the White and Bob litigation was, is there in fact a treaty on Vancouver Island, as the Aboriginal peoples assert? And if there is a treaty, what are the implications of it for things like the Provincial Game Act? And in that case, they went all the way up to the Supreme Court of Canada, remarkable political legal history where people like Tom Berger were brought in to work on appeal. He was then a very young man, lawyer from Vancouver. Political support from Frank Calder, the late Frank Calder, the great Nisga'a leader, who was then an MLA at the time. He was a major political supporter of that work. Guy Williams from the Native Brotherhood of British Columbia, another important supporter of the work of advancing the appeal of the White and Bob all the way up to the Supreme Court of Canada, where in 1965 the court agreed with the arguments that were put forward because the Crown was denying that there was a treaty, but they agreed. They said there is a treaty, it will be enforced today, and what it means in this context, in this circumstance, is that the provincial law cannot apply to infringe upon or to diminish the continuity of the treaty rights to hunt as formerly. So a very important principle that stands at the foundation of the modern era of Canadian Aboriginal law. And in that litigation, they first put forward the argument that there is a treaty and it matters and it will be enforced. They said if you disagree with that, our secondary line of argument will be that we will be talking about our Aboriginal rights and title as a defense to the charges. And so this opened up a remarkable history over the last half century in Canadian courts where they've been grappling with these issues. Over the course of time, there was the most important part of the Douglas Treaty jurisprudence for our conversation tonight is about how it pushes back on provincial jurisdiction. What it says is that if there is a treaty right to operate, the provincial law is limited in its scope. It cannot enter into or interfere with the operation of those rights. Now, what happened in other parts of British Columbia where there are no treaty rights is that it was a very straightforward, simple Crown belief up until the Haida Nation decision a decade ago in 2004, where the Crown's view and position was that we can do anything that we want with respect to the Crown lands of this province if we are not constrained by either a treaty that's been entered into by the Crown and Indigenous peoples, or unless there has been a legal decision that establishes some firm right. If neither of those two things are at play, we are unconstrained in our decision making across the province.
You know, and to this history Doug's giving, maybe just add, two things that I think it's important for the general public to understand. The first, that the whole, there's a part of the story, because Doug told a really condensed version of it, from 1927 to the 1950s, where it was illegal. It was effectively a crime for Doug to do the work that he does, for me to do the work that I do, for an Indigenous person to raise these issues or to hire a lawyer. That was added to the Indian Act in the 1920s after advocacy was really taking place to raise these issues of the lands being taken. So, you know, the story starts where it started in the 1960s in terms of the law, because it was a crime to deal with it earlier. And I don't think most Canadians are aware of that fact of our history. And the second aspect, I mean, just to take where Doug's last point is, you know, the fundamental question here that people have to ask themselves is, how did the land ever transfer from Indigenous nations to the Crown? Right? That's at the heart when he talks about treaty and Aboriginal title. And the answer to that question is, well, it never did. It never lawfully did. And that's the situation that we're grappling with today. I mean, we all know about how land transfers in our lives. Right. We don't expect anything other than that, right? We expect we have a transaction, there's a deed, there's a treaty, there's something. We make that make sense. Well, here it didn't happen. And that's the reality when we talk about reconciliation, when we talk about title, when we talk about grappling with this stuff. It's that basic historical fact that there is no answer to that question, that did the land transfer? The answer is no, it didn't.
So one of the things that we often talk about in Canada and British Columbia, we often hear about the duty to consult. Where does the duty to consult come from, and where is it founded then, and what is it based on?
Do you want me to
pick on that? With the Haida then. Yeah.
So I will. So I got up to the Haida litigation in 2004. And in that this was a major sea change in the relationship between the Crown and First Nations, of profound significance. Because up until that point, the Crown believed it was utterly unconstrained in its decision-making across British Columbia. They could do whatever they wanted. So what was happening was, up in Haida Gwaii, the Haida Nation was negotiating with the Crown in the treaty process about the subject matter of, about their relationship to the forests and everything else. Right. And at the same time that the Crown was sitting at that treaty negotiation table, they were also sitting at a different table with forest companies. And so while they were negotiating about the subject matter over here, about the forests of Haida Gwaii, at the same time that they were at another table with industry saying about that very same subject matter, we will grant you all of these rights, expansive rights to the forests of Haida Gwaii. The Haida people went to the court and said, this can't be right. This is not good faith negotiation. This is not, while we're trying to resolve an issue, you're giving it away at a different table. So they went to the court, and the Supreme Court of Canada agreed. The Supreme Court said in that important decision, they said the Crown is constrained in its decision making about these issues, even prior to rights being established. If there is a legitimate claim to Aboriginal title and to Aboriginal rights, that has to be taken into consideration in some way. Mm-hmm. And they said, though, they talked and referred to the honor of the Crown principle, and they said the Crown is always constrained. The honor of the Crown is always at issue in all of its relations with Indigenous peoples. That comes from the Crown's assertion of sovereignty over what is now Canada. That assertion of sovereignty gave rise to that duty related to the honor of the Crown, that it always has to guide their every action. And so they said, in the circumstance where there's a specific right, like an Indian reserve, the honor of the Crown gives rise to a fiduciary duty on the part of the Crown to safeguard and protect that interest. But when we don't have yet a specific interest like that, where there's simply assertions or claims, and the specificity of the rights has not been determined by a treaty or by a court process, then the honor of the Crown can't give rise to a fiduciary duty in that context, but it does nonetheless give rise to a duty to consult and engage and potentially accommodate with respect to how the decision may impact upon those rights. But this is for tonight's purposes, the most important element of this. This is a very important decision that fundamentally all of a sudden changed Crown First Nations relations in British Columbia and across the country, where now we've got to be, a decade later, we're sick of each other. We've been sitting across each other on every single issue and decision over a decade. Mm-hmm. And there's been all kinds of failures in that engagement, represented by the 200 different legal cases across the country that have been won on the duty to consult and the First Nations assertions and claims that the Crown has failed in its duty to consult. It's been an important but difficult, complex process. But what's important for tonight's discussion is something that's really critical, that the theory of the honor of the Crown and Haida Nation and the duty to consult is all premised and built around the fundamental idea that there is only one decision maker in British Columbia, and that is the Crown. And that as part of the Crown's authority and jurisdiction over the lands of British Columbia, as part of its decision-making process, it has to go and talk to First Nations and consult with them, engage with them, potentially accommodate, but ultimately they go back and they make their decision. And so when we move and shift this conversation into what consent is all about, we'll talk about how the model of consent that comes from, has been referred to in different ways in little bits and pieces in different law over different legal decisions over the last number of years, but really specifically in the Tsilhqot'in Nation decision from the summer of 2014, we'll talk about how we're now shifted into a fundamentally different paradigm of decision making.
So Roshan, do you want to pick up on that? Maybe
Yeah, I will. I mean, just before doing that, just one sort of different way of saying a lot of what Doug has already shared is that consultation and, you know, what everybody has talked about for the last decade is really just an interim step, is really just a moment in time towards getting to the place that we really need to get to, which is around the proper relations between governments and nations and decision makers and sovereigns. And that's the discussion around consent. And another way of thinking about why we're on this trajectory is that many times the court has been trying to encourage, by making decisions that create a lot of complexity, as Doug described for everyone, encourage us as a society, as communities, as individuals, as groups of people, to get on with the hard work of really building understanding, build new social relationships, build new economic relationships, build new political relationships. And because we haven't been so great at picking up that challenge, guess what? The court steps in and puts the pressure on again, and puts the pressure on again, and clarifies more and intensifies the pressure. And I think the last 5 or 6 years, and Doug may have a different, you know, I've been doing this about 15 years, and I could tell you I could walk down the street 15 years ago and talk about reconciliation and Aboriginal peoples, and people would most people would say, I don't have a clue what you are talking about. And now you walk down the street and it's in the front of everyone's mind one way or another, like they know something about it. And so there's been a sea change, and we're now positioned where we have to really grapple with these matters. I mean, even the fact of our topic tonight of consent is breaking out as an election issue provincially. It already did federally in various guises. You know, that is part of this ongoing process of social change and coming to terms with this stuff.
The courts have essentially, and I'm not a lawyer, the only one on the stage that's not a lawyer, has been nudging us, with their decisions, have been nudging the Crown and Indigenous governments towards saying, solve this, have these discussions, negotiate this, because having this resolved in the courts, well, it's a very expensive way of doing it, and it's a very confrontational way of doing it. And, you know, my family's gone through the Morris Olsen case, which you know, my dad will say has never been implemented. What happened after that case? You know, the Sanish Bay Marina case. What happened after that? Are we any further ahead than we were at the time that decision was made? So perhaps just a little bit, Roshan, about the Tsilhqot'in, the summer of 2014, and where maybe some of these discussions started to evolve and change and actually become much more public discussions.
Well, I would say, first of all, you said the courts nudge us, and I'd say maybe the summer of 2014 is when they went from nudging us to bludgeoning us a little bit and really pushing it. Because June 26, 2014 is the first moment in time, the first time in the history of this Canada, in this country, that any grain of sand had been acknowledged by any institution of Canadian government, in this case the Supreme Court, as being Indigenous land. The entire history of the country, that acknowledgement had not taken place. So that is a fundamental shift. It is, as Doug and I call it often, a rupture, a break from much of that history that he's described before, where all of these abstract concepts about title and infringement and rights, and in particular Aboriginal title, go to being something real and tangible. And at the heart of the case are two or three key issues. One is the whole fight that led up 25 years of litigation, very expensive for the Tsilhqot'in people, and a great burden in their community, and a great a benefit they did to all British Columbians and all Canadians over that time. The core question was, is Aboriginal title tiny? Is it just over small spots that we really shouldn't be concerned about, or is it over territories, over large areas? And the court was definitive. They say Aboriginal title exists over vast areas, over large areas. So in that case, it was 2,000 square kilometers in the interior of British Columbia. The second question, which really gets to the point you were raising about nudging us along to moving us along quickly, is, well, what does it mean that there's title? And what the court said there is that the full economic interest in the land, the full beneficial interest, is the Indigenous nations. Right? Not a little bit of it, not some of it, the full interest. And then the third thing that they do say is, and if somebody wants to do something where Aboriginal title exists, you have to get consent. Consent of the Indigenous group.
Even if I understand it right, even if something has been done a long time ago and then title is established.
Damages could be owed for that, things could be canceled. Right, so it's a remarkable thing in the decision that the Chief Justice of the Supreme Court, Chief Justice McLaughlin, writing on behalf of the court, sort of steps out of the judicial demeanor at one point, and she starts a paragraph. It's paragraph 97. She starts with the words, "I add this." Like, let me just say something here. If you want to do something with Indigenous nations on the land, whether you've gone through these long, painful court processes that Doug talked about or not, prior to a court saying title exists, you know what you should do? Crown, industry, third parties? Just go get consent. Right? This is the court saying, for all of the doctrine we've created, all of the rules, all of these things, at the heart of this, I am telling you, as a society, as people, and it's not just governments, right? It's all of us.
Right.
I'm telling you, go out and start grappling, building the proper relationship, building that in the real way.
And if I would add two things to this, because I think there's very important history for all of us to figure out how do we need to grapple with this moment that we're in. One is the reluctance of the courts over 4 decades to actually make a real decision about title was premised on the idea of the court that these issues are too complex to be resolved in the judicial forum.
Right.
And they made all, like from Calder through Dalgamuk, they were finding all kinds of legal technical reasons not to make an actual legal declaration. We're happy to create the theory, but we're not going to make a decision, but the theory should be prompting you. And then they started pleading and giving direction. Please go and sit down and sort these things out. And certainly in Dalgamuk, there was the reality of the treaty process was already in place at that time. So there was I think the judiciary thought and understood that there was a space to go and resolve these issues. And so they, even in, I think 2007, when the Tsilhqot'in Nation trial level decision of late Justice David Vickers was issued, he spent 20 paragraphs in that decision imploring politicians, governments, First Nations governments, the Crown, go and sit down and work on reconciliation. And in his words, he said, we are ill-equipped in this forum to deal with the complexity of these issues. So please go and sort them out. Now, what happened was, by now 2007, that was probably the last time it was plausible to say there was really a political space to go and resolve these issues. And certainly by then, groups like the Hulkaminum Treaty Group, they went to the Inter-American Commission on Human Rights down in Washington DC, and they said, we want this international body to say something about the fact that in Canada, we have no path to have our Aboriginal title demarcated and recognized. And we believe that infringes our human rights as Indigenous peoples, and we want you to say something about that. Canada stood up and really pushed back on them being in that international forum. They said the Hulkaminam have no right to be here because they have not exhausted their domestic remedies, as they must as a principle of international law to have standing in that kind of a forum.
Right.
Dozens of First Nations across the province and across the country put forward amicus curiae briefs, friendly briefs to the commission to tell the story of litigation on Aboriginal title in Canada and to tell the story of their experiences in the treaty process in British Columbia.
Right.
And they said for 4 decades, not, as Roshan says, not one decision has been made that recognizes Aboriginal title. After decades of effort, tens of millions of dollars of effort spent to try and get a title decision, the courts have never provided a remedy. And then they said the treaty process, for its part, quite the opposite of implementing title, actually asks Indigenous peoples to set their Aboriginal title aside and to take something different in its place, fee simple. Mm-hmm. And so in a very embarrassing decision for Canada, the Inter-American Commission agreed to grant the Hulkaminam Group standing and said the legal process is providing no remedy, and the treaty process is not about implementing title at all. That combined with this decision of the court from the BC Court of Appeal that really adopted on the Tsilhqot'in decision, that really firmly grabbed a hold of all of the Crown arguments about title to date, to that point. That title is, if it exists at all, it's very narrow in scope, it's very limited, it's not something that really, and the BC Court of Appeal decision really grabbed a hold of that, the arguments of the Crown, and confirmed them. Those two factors, I think, really put in place the need for the Supreme Court of Canada to make that major decision that Roshan talked about as a rupture.
Right.
And so now, so that's an important part of the history to understand, that the decision came because of a political failure to have meaningful discussions to resolve critical issues at the core of Canadian British Columbia society.
And a social failure and an
social economic failure
at every level.
Now, so there's that dimension, and then the other related issue to the Tsilhqot'in decision has to do with how, when the decision was made, it opened up a fundamentally different space and a new space that hadn't existed to that moment. Okay. And in the way that it talked about Aboriginal title, a really important element of the decision is the governmental relationship of the Indigenous peoples to their Aboriginal title land. That there is a decision-making power. And so earlier I talked about Haida Nation being, there's only one decision maker. Yeah. Tsilhqot'in said very clearly that consent comes from the reality that there's a recognition that Indigenous peoples have decision-making power about Aboriginal title lands. And then so, first of all, first and foremost, they have that power because they should be determining their own reality, their own future, the way that their landscape unfolds is firmly within their grasp. And that's what Indigenous peoples have always been seeking to achieve, right. To reestablish the relationship with their territories and to be able to make decisions about those territories. Now, secondary to that first priority of Indigenous peoples is now contending with and dealing with the continued attempts at incursions into their territories by the Crown. And so the court said in this context, consent is the only path. And they said, most importantly, the depth of the uncertainty is such for any decision maker, whether Crown or industry, contemplating whether or not, should we invest multiple billions of dollars in LNG infrastructure or in a pipeline, mm-hmm. or whatever. The court said very clearly, if you make this decision without the consent of the Indigenous peoples, you need to understand that your project is subject to cancellation in the future when title is finally established. So now, in my mind, every CEO is now at an incredible, when they do their risk analysis across Aboriginal title spaces, if they're suggesting to their board and their investors that, I want you to spend your multiple billions of dollars in a space where there may be Aboriginal title, Without First Nations consent, they are taking not a major risk, they are taking a total risk. And so this is something where it creates a challenge for all of us, that we all need to, First Nations, the Crown, industry, need to work together to overcome this depth of uncertainty, and the only pathway of that is through consent. And I think we should talk about what consent is.
Yeah.
And we'll get there. I think that we'll just get to there. I think that what we've seen since it's now it's now 2016, right?
Yeah.
We're now past 2 years past the Tsilhqot'in decision. The posture of our provincial government is not to accept, from what I can see, doesn't appear to be to accept the decision of Tsilhqot'in. Consent comes up not in the context of this entire legal framework that this picture that you've been painting that's been going on for the entire existence of Canada and before. It comes up in the context of the UN Declaration of the Rights of Indigenous People. So the federal government, I think it was a few years back, before this government finally accepted it after being one of 4 countries to say no, finally accepted it, and then in the federal election, soon to be Prime Minister Justin Trudeau and the Liberal Party of Canada said, we'll adopt it. And so, but now there's this big issue about consent, the consent clause within UNDRIP, or the UN Declaration, like it's some kind of new, it's just being introduced to us for the first time. When in reality, if I get what you're saying, if I'm reading it, if I'm hearing you correctly, this is all, consent has been something that has been threaded through this discussion right from day one.
Absolutely.
I mean, just on that specifically, there's many other instances of consent appearing in various ways in the jurisprudence, in the law prior to Tsilhqot'in, and we could have recounted those. But also, consent is inherent right from the outset, right from that early James Douglas treaty-making days that Doug described, because it was about sovereigns coming together and sorting out their relationship based on their respective authorities, respective jurisdictions, and the notion that they were going to have to agree for things to go along. Now, just leading into a bit more discussion about what consent means, I mean, largely the story we've told is a story of avoidance, right? It's a story of avoiding grappling with these real issues. And you know, the reality of this is that the more we've avoided, the ever more complicated that we have made it for ourselves, right? I mean, so much so, I mean, Doug talked about, you know, most of the dialogue over the last 25 years, since Section 35 of the Constitution came into being, which spurs a lot of the case law that we're talking about and a lot of the work that we're talking about, most of the dialogue has been, how can we get First Nations to give up on those rights? To extinguish them, to surrender them, to change them. And we should just think about how ludicrous a notion that is. I can't go to you, Adam, and say, you know what? I'll give you $1 million if you give up your right of free speech. Right? Like, we would never even ask the question of each other.
It's fundamental, inherent.
It makes no sense.
Depending on how desperate I am.
Yeah, but even to ask the question, like I could make the transaction, but I couldn't hold you to it.
Yeah,
because there's something inalienable and inherent about that right that you have as an individual. The only group of people in the history of this country who've been asked to give up their constitutionally protected rights that we would even fathom, a government would even fathom that they could ask, right, as wrong as it is Indigenous peoples. Like, that's how steeped the avoidance is. Right, and it's brought us to this very difficult place. You said, you know, consent is not really being grappled with, the implications of Tsilhqot'in. That is carrying on this pattern of avoidance, of denial. And it is, you know, the difference from 2014, what we know now, is that failing to grapple with it is passing a liability on the taxpayers of this province that is accruing more and more and more every day. It is fiscally, morally, politically bankrupt and irresponsible to not be doing that. You are forfeiting future generations of all peoples by doing that. This is what the court thought they would do when I said they bludgeoned us collectively, like, get on with it. They brought it right to the heart of the economic reality of society as a whole.
Unfortunately, I think that the burden of this has been put on Indigenous people, that this is somewhat Indigenous people's fault, that this has happened to, the rest of the province and the rest of Canadians and all those people that do that. And I think that it was mentioned earlier in this interview that it's emerging as a wedge issue. We're going to be having an election here in British Columbia next May 2017, and it's emerging as a wedge issue. The NDP said that they'll adopt UNDRIP, and then in an article written by Keith Baldry, he quotes, Premier Christy Clark agrees with much of the declaration, speaking of UNDRIP, but has said there is no way her government would adopt resolutions that grant any such veto, and we can get to the veto piece here, which in her words would allow a small community to dictate the economic policies of the majority. And this is a quote from his article. So there's this suggestion that UNDRIP, this idea of consent, provides veto, and I think that it goes to Indigenous people. It goes to a lot of the groundwork that Doug has laid out here with respect to the one decision maker, and so maybe we can end this interview with providing some insights into that. Maybe we'll start with you, Danesh.
Yeah. So why don't I'll say 5 or 6 general points about consent and veto, and then I think Doug, has a lot to add, both about the context of the debate right now. So number one, as Doug has already outlined, consent is both in domestic law and in UNDRIP and in many articles of UNDRIP. So we shouldn't be some notion that it's some external UN declaration that has awoken us to this. It's been part of it all along. Right. Second point, consent and veto are not the same thing, but they're expressions of the same underlying realities. The reality that they're an expression of is the one Doug talked about.
One
two
decision
sovereigns.
maker.
There's 2 sovereigns, right. 2 decision makers, 2 jurisdictions. They each have their own authorities and decisions to make. Neither of their authority is absolute. Neither of their authority is complete. And for a lot of things to happen, they're going to have to align what they do, figure out the relations between them, get on the same page.
Sounds like dozens of decisions that are made.
Sounds like marriages, family life, sounds like, the point is there's nothing, that is intrinsic in the Canadian Constitution, not just with Aboriginal peoples and Indigenous peoples in Section 35. That's the way our federation works. Veto could also be the expression of distinct governments and jurisdictions, but that's the notion that one has the authority and a superior relationship to go in and trump the decision of the other. Trump's maybe a bad word tonight, but trump the decision of the other, right? And that's not, right? That's not the nature of this relationship between Indigenous peoples and the Crown. That's not the nature of how the Canadian Federation works. No, we use different language, but we have systems of different governments having to build the structures between them, reach decisions that reinforce each other and align them. And their power is not absolute. There are ways for, if consent isn't given, for the Crown to still try to do things. There are situations where Indigenous nations will choose to do something the Crown might not agree, but there's nothing they can do it. And there's a whole host of things where they need to build the structures and processes between them to do it.
So it sounds like this very divisive kind of language, this rhetoric that's coming out from the Premier, is an attempt to try to once again put Indigenous people outside the economy, outside of society as a whole, and to be an external force within this economy of British Columbia. I don't know.
Well, I'll just say one thing to that and then maybe let Doug pick it up. Sure. But what I would say is we need to ask ourselves what language, what ways of talking, what modes of dialogue are the ones that reconciliation demands, right? There's something about this moment in history, about this challenge facing us as a social justice challenge, as a societal challenge as a whole for all Canadians, that sort of demands that it be above politics in some way. Right. That reconciliation itself is a form of work that requires moving out of adversarial patterns, moving out of competitive kinds of language. You always have to be building the language that helps people see the integration, interconnection, and how to work together. right? That's even the difference between the language of consent and veto, as you pointed to. Consent, right? I don't say, yeah, my spouse can veto my decisions on, but I sure as hell think about how we have to be aligned and on the same page on a lot of things. And that's, again, the court using language that is pushing us together rather than pulling us apart. We have to do that as a society as a whole.
Okay. Do you have any?
Yeah, I think I really, the idea that UNDRIP is something that prompts or something. I mean, I think, this is a discussion we need to be having if UNDRIP didn't even exist, because it's a fundamental part of Canadian law. And we're still in the very early moment of having to revisit that original policy of denial that started in 1854, that now the Supreme Court of Canada in 2014 fundamentally stopped and blocked and said, to the Crown, they said, your arguments are incorrect and wrong. It's hard to explain the depth and the breadth of the uncertainty that the decision raises. It's important to reflect upon the fact that every bit of Crown law and policy about the lands of British Columbia, about so many important things, are all premised on the idea that Aboriginal title doesn't matter, or that if it does matter, it only exists in very small spots. And so this idea of consent is sort of the sharpest point of a bigger issue of the Crown having to reorient itself from denial to grappling with what recognition means. And what, as Roshan said, what does it mean to be in a proper, respectful relationship of recognition with Indigenous peoples, where we recognize that their relationship to their territory matters? If we do that, if we recognize that Aboriginal title is not dependent upon a legal declaration or a treaty, that in 1846, when the Crown asserted sovereignty across the landscape of British Columbia, that was the moment that Aboriginal title crystallized under the legal theory. Well, it's been there. It's there today. It's always been there, but that reality has been denied. And now the shift to recognition and grappling with that reality is going to take hard work. Profound uncertainty has been unleashed by the decision across British Columbia. Right. And this is a great challenge, not just for the Crown, not just for industry, it's also a great challenge for First Nations, but it's something that we have to rise to and acknowledge and grapple with together, because if we don't, the issue of consent, the idea that Indigenous peoples post-Tsilhqot'in are going to continue to stand on the side of the road while truckload after truckload of logs or truckload after truckload of minerals, whatever it is, being taken out of their Aboriginal title lands for the benefit of someone else, that status quo is fundamentally broken and a part of the past. And there is going to be real sharp conflict and profound uncertainty in this province if we don't start grappling with and dealing with the need to build proper pathways together. And so consent is one element of that. But it's going to require that profound and important shift from denial to recognition. And not the window dressing of recognition. Not the simple, easy things to say, oh, we're sorry. It's the real on the ground steps that have to be taken that will convey and be manifestations of a fundamentally different approach to the relationship. So consent is one element of a broader change, a massive paradigm shift that is prompted by the Tsilhqot'in Nation decision, the Truth and Reconciliation Commission, the UN Declaration on the Rights of Indigenous Peoples, the promise of Section 35. It's all of these things are coming together, and I think that we're at a really fundamental moment in our relationship where we have to return now to the first principles and the first questions of our relationship together. Who are we respectively? What is our proper relationship together? What is our proper respective relationships to the landscape of what is now called Canada? We have to now return to those original questions about what this country is about, what this province is about, what's the relationship and proper relationship of Indigenous peoples to territories. That's our work now. and it's very urgent.
So we've come a long. I mean, we've come a long way. A lot has happened over the past century and a half or more, and there's been a lot of denial, as you've pointed out, and a lot of blaming. To be frank, growing up on the reserve, I felt it. I look across the street from where I live, and I see very established communities of people that are going about their life, doing their thing. And the one group that you didn't acknowledge in that are the citizens of British Columbia and their role that they play in this. Because ultimately, the way politics are going, it's being driven by what politicians are hearing are important issues. They're going to adopt those colors and go with it. And so what can we say to the broader, the general public of British Columbia to say, how do we get this issue so that the government stops looking at how maybe it could have its advantage, or maybe how it could ignore it for another 20 years, or kick the can down the road another 100 feet, so that it becomes an issue that we deal with in a responsible and mature way, rather than one where it's just a bunch of people screaming around blaming each other, which I think could end up being, it doesn't work well for me if conflict is the answer for this. As a guy who comes from a mixed background, that doesn't work well for me. It doesn't make me feel comfortable or happy about my situation. So where to from here? How do we, other than the government just moving very quickly from where they are, denial to the next stage? Do you have any insights into that?
Yeah, well, I think it's very important for Canadians to be knowledgeable, and I think this has been a really critical theme over the last decade and longer of, as Roshan said earlier, there's been a profound shift in Canadian knowledge about these issues, far from complete, far from a lot of imperfections about it. We see how challenging it is to understand the issue of consent and decision making and how the jurisdictions interplay with each other. This is complicated stuff, but you're absolutely right about the fact that this is a challenging. If we're trying to resolve these issues on electoral timing frameworks, as opposed to understanding that this is the work of our society at large, and there's a role for citizens to play in this, then we're missing the point. Because it's true, it's essential for this work to be driven by all of the people. We need to understand that we're all at risk if we don't change the patterns of behavior from denial to recognition in meaningful ways. Then we're putting our economies at risk, our social well-being at risk, all of the different elements of our lives as human beings in British Columbia are diminished by that failure.
Yeah. Go ahead.
No, I just say that oftentimes that's an Indigenous issue, or that's an Aboriginal issue, and I often say to folks, an Aboriginal issue is a everybody issue, right? This is not about, as the Premier sort of alluded to in her comment, this is not about one group as part of, trumping, again, there it is, the economy. This is about us recognizing the fact that we are all part of the economy, and the decisions that we make are important.
If you live in Victoria, whether you're from Tsartlip or Tsilhqot'in, a member there or not, everyone that lives in this region they're all treaty people. They're all intended to be living in a treaty relationship under the pre-Confederation treaties of Vancouver Island, and everyone has a role in that.
It's not by chance that the issue of reconciliation arises with intensity at this moment in history. We are at a time, if everyone watching asks themselves about the real reality that we live in now, we live at a time that it is impossible to separate ourselves from each other. It is impossible to meet my challenges, my needs, for my family to thrive without recognizing the interconnection and interdependence with all of those surrounding me, not only locally, but even globally in real ways. Whether it's the healthcare system challenges, whether it's the education system challenges, whether it's resource extraction needs, whether it's the future of the economy, that can only work when we are all recognizing and working from a standpoint that sees the interconnections between us, and that all of us have fundamental necessary roles and work and interconnections that have to be built on. This work of reconciliation and conflict are antithetical to one another. Reconciliation, by its very nature, implies building the patterns and structures and ways of relating that are grounded in unity and interconnection and recognizing our fundamental indivisibility with each other. If I am bringing a conflict orientation to it, I'm failing in that work. If I'm not thinking and learning in new ways, as Doug described, I'm not playing my role. If I am drawing a line and a barrier and a division between myself and the Indigenous peoples or my community and that community, what I am setting up is the suffering and weakness of all of us to meet our shared goals. I mean, this is the moment in time we are live in, and this challenge, more than any other that Canadian society faces, typifies that. There is not one social, economic policy question that can be adequately addressed, environmental policy question, without grappling with, as Doug framed, the proper relationship and role of ours, of Indigenous peoples and all Canadians together. There is none that can address it.
So this is precisely the reason why reconciliation needs to be above politics.
That's right.
Because our political structures in British Columbia and in Canada, as we get to Canada's 150th birthday, big celebration next year, the political structures in our country and in our province are conflict-based in their very nature. They sit 2 sword lengths away from one another in the legislature, simply so that they don't, I guess, stab each other or something with a sword, and the very comment and the article that Mr. Baldry wrote, which was the BC NDP takes this position, and the Premier responds with the opposite position, that this is going to become a wedge issue in the 2017 elections. Actually, really it frightens me. It reminds me back of 2002 when we were asked 8 questions that were completely irrational in the grand scheme of things, and didn't help us get to where we need to be. In fact, set us back. And so, reconciliation above politics. Reconciliation is about the actions of all of us, right? Not about what we're saying or about the talk or the rhetoric, but about how we're acting and building the relationships across the street and with our neighbor.
Absolutely.
Any final comments? They're going to give us the wrap up here pretty soon. You want to?
Well, I mean, I think that, captures, just to close it by where we started, which was around this issue of consent, and what you just said, is we have fundamentally failed if we spend the next number of months or years talking about consent yes or consent no, should we do it, should we not do it. If we would just turn to the conversation about how might we do it, what might it look like, how might we build those structures and relationships and understandings between us, just that little shift from should we to how might we would be getting into the right kind of conversation. And we're still stuck in the wrong kind of conversation.
We got 1 minute left. I need to do a little bit of a wrap up. So do you have any final thoughts on where you would like to leave this?
No, I'm just, I think it's the First Nations, in my view, are willing and ready to have that conversation about consent and helping to provide that clarity to talk about how their decision making works within their territories, within their nations. And so they've, in my experience, have been offering up the very conversations that Roshan and you have been talking about. And I think it's incumbent upon the government to help to foster and lead the people of British Columbia, the industry, all of us getting together to try and help each other through this time of great uncertainty and to build a better, proper path of respect and recognition.
Roshan, Danesh, Doug White, thank you very much for joining me this evening. And I really hope that that this conversation will be able to provide British Columbians a little bit more information as to how we got to where we're at, and hopefully shed a little bit of light on how we're going to get to where we need to be, which is one community that acknowledges and respects all of the differences and the diversity that we have, so that we can advance together as a province, and we can advance together as a country together and as one, and not with these divisions, and not with the issues that we have seen over the past 100 years where we're not admitting to who we are and where we come from. So thank you very much for giving us your insights, and I look forward to the work from both of you in the future.